start this story 20 years ago, the US Congress passed a law that really didn't have much of an effect on trade, didn't have much of an effect, period. But it did require the Department of Defense to make a list within 6 months of the law, which was passed in 1999, of companies operating in the United States that were owned, controlled, or affiliated with the Chinese military. And in the US, and I don't know if it's the same way in China, sometimes Congress passes laws and nothing happens.
Mm-hmm.
And this was a good example of Congress passing a law where nothing happened at all for 20 years. But last summer, and I think at the instigation of a couple of very anti-China senators in our US Senate, the Department of Defense decided that it was going to start listing those companies. It was put together so quickly that they hadn't really figured out exactly what they were trying to prohibit. But at the end of the day, what they prohibited was they prohibited US persons. So that's, US citizens, green card holders, companies organized in the United States from owning and then essentially purchasing or trading in the shares, the publicly traded shares of companies that were on this list. So that was a big deal, especially for companies that had, and it was any publicly traded. So it's any stock market. It's not just the US markets, but it's markets around the world.
Pension funds, you've
exactly.
got huge institutional funds, right?
Companies in the US that were put onto the list. And particularly Xiaomi, which was put on the list a little bit later than the original listings, but was put on after the president's executive order and was facing the possibility that US persons would not be able to invest in their securities, brought a lawsuit in the United States. And they brought a lawsuit under both the Administrative Procedures Act, which is a law that allows companies and persons to challenge agency actions, so actions of agencies like the Department of Defense, and also under our US Constitution, in which guarantees due process. And they pointed to the 2-page memorandum the Defense Department had put together, making this determination that didn't really say much other than that Xiaomi was a Chinese company and it had some undefined connection with the Chinese military. But in addition, we don't think they use the right definition of affiliated. So the term affiliated, everybody agreed that Xiaomi is not owned or controlled by the Chinese military. But the question was, were they affiliated with the Chinese military? And Xiaomi took the position, and ultimately it was successful, that they were not, that the right definition of affiliated is that it's effectively controlled by another. So there's owned or controlled, or essentially effectively controlled by another, or under common ownership or control. And that was really important because once it accepted that definition, it was really clear that Xiaomi, which was a publicly traded company, produced products for civilian use, controlled by an independent board of directors and shareholders, was not effectively controlled by the Chinese military. And the court found that Xiaomi had met the standard of likelihood of success because there really was no showing in the Defense Department memo that they were affiliated under the proper definition of the term with the Chinese military. Earlier this month, after this ruling, Xiaomi settled with the Department of Defense, and the settlement was not really a settlement at all. It's basically the Department of Defense agreed that Xiaomi won the case and was not going to be on the list and was not going to be subject to this prohibition.
Honestly, if you take a step back for a second, that a Chinese company can bring a suit like this in US federal court and win. And it just shows you the robust system we have. I think a lot of people, let's just say outside of the United States, what might be surprised Xiaomi could bring this case, and the government would have to actually divulge that 2-pager that you said, the document that shows the factual analysis that they used to make this determination of putting them on the list. That's publicly has to be disclosed, or at least has to be disclosed to a party bringing the litigation, right?
So on the one hand, you have a Defense Department that does not have the institutional kind of buy-in that the earlier Defense Department had. I mean, the Biden Defense Department did not put these companies on the list for the most part. Right. And so they're not going to be as invested as in defending this list as the earlier Defense Department might have been. So I think there is some there is some likelihood that with respect to companies where it's clear that they don't meet Judge Contreras's definition in Xiaomi of affiliated, that you'll probably have the Defense Department settling those cases. And so I think that there will be cases where there is more of a dispute whether or not the company meets Judge Contreras's definition of affiliated with the Chinese military, that will still go to litigation. But I do expect to see more litigation in this area, in part because not only was Xiaomi successful, Luokung was successful, but we've had a number of other, WeChat and other companies have been successful in challenging some of these national security orders. That is a big deal in the U.S. because I can tell you, 2 years ago, and certainly 4 or 5 years ago, the idea that a company could go to US courts and challenge an order that was based on national security grounds and win quickly, like these cases have done, it was really unheard of. And now it's happened, at least 4 times that I can count in the last year.
And the analysis was that if we go with the Department of Defense's definition, very broad definition, that would essentially be a rabbit hole, or that would be such a broad definition that you could almost throw every company into that definition by the nature of how China works, and probably even other countries you'd have a similar situation.
I definitely think the DoD will become more careful because it's lost twice in court. I think they've seen now that they're not going to get away with just like throwing any explanation out there and having a court say, well, it's national security, so we're not going to really review this closely. So Congress passed the statute, the president signed the statute, and in our system, because it's so hard to get the House of Representatives and the Senate and the president to agree on virtually anything, they'd need to go back and get a new law in order to change that definition.
Well, in China, the system is a bit different. The more politically correct way to describe it is a market-oriented system, but there is a lot of involvement of the state, right? And that's by choice. I do have some sympathy for trying to craft rules that are not too broad but not too narrow and not have too many, again, quote, holes in it. It's a bit of a game of whack-a-mole, I think, in some ways, especially as I've, in my experience, dealt with export control lists over the years, because if you really that list should almost be updated in real time, because it's so easy to reincorporate or to get the names wrong, right? In fact, one of the, as we were joking about before, we were making light of the fact that the judge in this case, right up front, very quickly off the bat, acknowledged that the Department of Defense got the name wrong of the company in the case of Luokung. Again, the Chinese would be Luokung. And I have sympathy for that even as well, because you would do, and I think the explanation was they got the transliteration wrong, which is true. I mean, I think they still is not actually quite a good excuse as I saw it, but there are different ways to put the name in from Chinese characters into a Romanized alphabetic spelling. So I guess my point is, I have some sympathy for these poor folks that do have to try to come up with these rules and define things. But I still think the judge was right to say, look, you could go to the company's website. This is the listed traded name of the company, right? It's pretty easy to get the name right. And that by the fact that you didn't get the name right,
it could be said about many companies in the United States.
Right.
I mean, there's many companies here in the States that have some undefined connection to our U.S. military. I mean, we spend a lot of money on the military, and there's a lot of U.S. companies that sell things to the military or do things with the military here that are not affiliated in any formal sense of the term with the U.S. military, but certainly have enough of a connection to the U.S. military that if China were to make a similar list, it could put those companies on a list of U.S. companies affiliated with the U.S. military in the same way. So it's one of those things where if the Defense Department had been really careful and this had been an isolated slip, I think the judge wouldn't have even mentioned it. It would have looked petty. But where they were so completely careless, and it was just kind of, we think you'll buy off on anything, so we don't even have to get the name right. I think the judge decided to say, if you want to be that sloppy with me, I'm going to call you on it.